Vic, what's the last name on this gentleman?
Wilkins, age 21.
You're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant was told the defendant to get ready for rehab. The complainant was noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Do we know he did it?
Your Honor, it stated that there was.
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
A bass guitar.
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
Oh, Your Honor, it was.
Stop.
Oh, my fault.
Stop. Don't
Fuck.
say a word. Are you losing? So why talk?
I'm not sure how the police were contacted here, Your Honor. It just says that they met and spoke with him.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, she's facing events. The defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen, which was a bicycle, was later stolen from the defendant when he left it at his store.
But here he's charged with a bass guitar. What the? I have a pet lizard named George. Really? Mr. Wilkins, I'm going to find that there's no probable cause to go forward in your case.
This judge isn't just ruling, he's preaching. Life's hard enough as a black man without theft convictions. Mic, drop. It's a rare moment where the system acknowledges its own biases. But here's my question, should judges give life advice, or just stick to the law? Comment below.
Life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a black man in today's society. And when you start racking up convictions, especially theft convictions where you branded a thief, do you think it helps? No, it doesn't. Get into school, get some knowledge, get a degree, find something to do, and make a lot of money. That's what life's about. Not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please. What happened with upstairs?
We're gonna go on a 15 months deferred down here, and it's gonna get resolved.
They're going to dismiss that one in exchange for this one?
And
And the weed? Got it. Okay. You know, there's not many times that you're going to be afforded this kind of deal where they're going to dismiss a felony in exchange for a plea on a misdemeanor. So I would be very, very careful. If all this stems from self-control or usage of
A felony dismissed for a misdemeanor plea. That's a sweet deal, but there's a catch. Deferred probation means one slip-up equals jail time. Pro tip, if you're offered this, read the fine print. Also, why is the judge warning about devil incarnate drinking habits? Plot twist incoming.
dope or alcohol. I mean, really, there's some people when they drink, they become the life of the party. They're happy, they're fun to be with, they crack jokes. And then there's some people that turn into the devil incarnate. If that's you, then this should be a wake-up call. If it's not, what's it going to take? 25? You're charged with two very serious offenses. You have the assault down here, you've got the assault upstairs. They're going to dismiss that felony assault in exchange for this one. You're entering into a very serious probation where it's a 15-month deferred. This is a type of agreement where if you complete it successfully, you do not end up with a conviction on your record, but it's not dismissed. If you complete it, there's no conviction, but you can't tell people it was dismissed. It's not dismissed. Just you complete it successfully, you don't end up with a conviction on your record. You need to understand that there's still an affirmative finding of family violence. You pick up another one of these, you're looking at a third-degree felony, another 2 to 10 at the penitentiary. Do you understand? You can also never own a gun or ammunition as a result of this plea bargain agreement as well. Do you understand? Is this what you want to do? You give up nearly every right known to man by entering into this agreement saying, look, I'm going to make it, and if I don't, you can put me in jail for an entire year. That's the agreement that you're entering into now. So for you to complete this successfully, you must do a batterers intervention prevention program. This is a tough one. This is a class that you have to attend once a week for 18 weeks. If you miss it, they're going to kick you out of the program. If you get kicked out, we issue a warrant for your arrest. We'll have a hearing here to see if you violated. No drugs, no alcohol. You will be tested like crazy to ensure that you're not using. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them as well. 20 hours of community service, $100 one-time donation to the family violence provider, no threatening or harassing abusive contact with Mr. Cockrell. Do you have children? I think that in lieu of community service, I would like to do a parenting class. And if she does a parenting class, then I'll waive the community service. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you're stuck with this until you complete it successfully or it gets revoked. Do you understand? I like to reward people. I like to encourage people to do well. And what I normally do is, if you do well in this agreement, if you don't test positive for dope or alcohol, you get all your classes done and you're nice to everybody, I'll take you off in half the time.
Okay.
So you can be done in half the time. Just be nice. Don't pick up any new cases and don't use. You understand? Is this what you want to do? How do you plead to the offense of assault of a family member? Guilty or not guilty? I'm not going to find you guilty now, Miss Loyola. I'm going to wait, essentially, for 15 months to see if you're able to comply with this. As part of this agreement, the possession of marijuana will be dismissed, and your other case upstairs will also be dismissed as well. Do you get child support for the children, or? Okay, cut her fees. It's never about the money. I don't care about the money. I care about you doing what you say you're going to do and showing up and doing it on time. The worst possible thing you can do is either pick up a new case or abscond. You just take off. That's an instant warrant in this case. You understand? So if you ever have any problems, come back. We can always work through it. We can talk about it. But just doing nothing and taking off, it's the worst thing that can possibly happen. All right, so I'll follow the agreement, send it to everything. Good luck to you, ma'am. Good morning, Ms. Blewett. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, officers were dispatched to an assault and progress call. The officer met with complaining witness one, who stated that he, the defendant, and the other complaining witness were in a polyamorous relationship. The first complaining witness stated that the defendant had sent numerous texts and calls and showed up unannounced at the residence. The first complaining witness stated the defendant struck him in the face while the defendant had a phone, causing pain and a tooth to become loose. The second complaining witness stated the defendant arrived at the residence, and while complaining witness one was trying to calm down the situation, the defendant struck complaining witness one in the face, and in the process of breaking the fight, the second complaining witness was struck in the shoulder, causing pain.
But we only have the assault on the gentleman, correct?
The assault's only on the, I'm sorry?
The gentleman.
I believe so,
You
yeah.
only got one count.
Yes, sir.
Okay. Ms. Blewett, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, there's a protective order that has been issued in this case. You need to get to know it. If you do something to violate the protective order, the state can and probably will file additional charges against you. Do you understand?
Yes, sir.
I'm ordering you not to have any contact with this person and not to be in possession of any weapons. If you violate this, I will revoke the bond, put you in jail. No more PR bonds for you, man. Do you have the ability to hire a lawyer?
Court appointed lawyer, court appointed.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. I'll take a look to see if you qualify. I need to know everything about you, how much money you have in the bank, how much money you work, and I'll take a look if you qualify. I'll have you sign a receipt. Victoria, Deputy Miranda's going to give you an application, and I'll have you take your seat in the jury box. Do not leave until you sign our bond condition. Bond conditions. Can you file no contact, no weapons, please?
You try. So no contact, no weapons.
Yeah. Good morning, Mr. Delaney. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, a law enforcement officer responded to a trespass at a gas station known for being a drug trafficking hotspot. Law enforcement officers witnessed surveillance footage of the defendant making multiple hand-to-hand transactions and throw something in his vehicle when the law enforcement officers originally approached the gas station. The law enforcement officers detained the defendant and approached the vehicle and witnessed 2 sacks of marijuana on the passenger floorboard area in plain view. A probable cause search was carried out, and the officers identified the 2 sacks on the passenger floorboard as marijuana. The total weight of marijuana was 76.37 grams.
Mr. Delaney, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand? I'm also ordering you now not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand?
Good.
No more slinging. Do you understand? What do you do with yourself these days? Do you have a full-time job?
I'm doing application right now. I have an interview tomorrow.
Good. I'm bringing you back in 2 weeks, and I want to see that you have a full-time job. Do you understand? If you come back and you've done nothing, it's not going to go well. And I'm telling you, I'm going to drug test you within the next 50 days. If I find that you continue to use, it's not going to go well for you. You understand? All right. Did you want to apply for a court-appointed lawyer? Okay, Deputy Miranda's going to give you an application. I'll have you sign a receipt with Victoria. You will then meet with Fleischer for your bond conditions. I'm also ordering you not to be in possession of weapons as well. Do you understand?
Yeah.
Okay, come on. What, you said 15?
15 is GD.
What's your?
15 is GD.
Yeah, but hey, 15?
Oh, I'm sorry. Phillips is on page 15.
Yeah, okay. You're, Mr. Phillips, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On September 1st, 2023, a law enforcement officer responded to failure to stop and give information call in Harris County, Texas. The law enforcement officer made contact with the complaining witness, who stated that she was pulling into a parking lot of a corner food store and observed the defendant's vehicle reverse into her direction quickly. The vehicle then rammed into the rear driver's side of the complaining witness's motor vehicle. The defendant's vehicle then quickly shifted into drive and fled the parking lot. The complaining witness took a photo of the rear of the defendant's motor vehicle after the accident and provided the license plate to the law enforcement officer. Law enforcement officer found the motor vehicle registered to an address less than a mile away and traveled to that address and made contact with the defendant. The defendant said he was at the food store bursting out of the parking lot and struck the complaining witness. The defendant stated he fled without providing information because he did not have a driver's license. The defendant was identified with his Texas ID.
So, can you run his license, please, just to make sure?
Yeah, sure. I'm just not showing the driver's license numbers, so I'm not sure if he is part of the license since then, but we don't have it in our system.
If you do not have a license, do not drive. I don't care what's going on in your life. I don't care that you have to go to work. I don't care that a baby needs to go to the hospital. I don't care there's a burning building and you need to save 50 kittens. If you don't have a license and liability insurance, do not drive. You will be signing an affidavit with me today. This is a promise that you're going to make, that you're not going to drive. You cannot justify getting into a car for any reason. And if you do, You can be facing an additional 6 months in jail on a contempt charge every time you drive. It's an offense in and of itself. Do you understand?
Yes, sir.
What do you do with yourself these days, Mr. Phillips?
I work and take care of my little sisters. My dad had recently passed away.
You have a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to qualify. I need you to fill out an application. I'll take a look to see if you qualify. I need to know everything about you. Do not drive, Mr. Phillips. If you want to drive, go get a license, get insurance, show me that you have these, and then we can talk. But until that point, don't do it. There's going to be HE double hockey sticks to pay if you do. You understand? All right, come on.
Robert Shelby and the holdover, you wanted to, Bill Stratton had to leave, you wanted to.
You mind? Yeah, please. So I'd like to do PC. I just want to know, because it's a DWI second, there's also an evading. If you could just give me a brief rendition of what happened, please.
Yes, sure.
When he comes out.
Yes, sir.
Morning, Mr. Shelby.
Morning.
So your lawyer was here before I got here, and he had to leave to go to a funeral. So I wasn't able to, at that time, to do conditions, but I want to put bond conditions on you because you now stand charged with a driving while intoxicated, second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, a maximum of 10 years in prison under Texas in the TDCJ. So can you please give us, you have the right to remain silent. Anything you say can or will be used against you, sir.
Good judge. On April 3rd, 2025, in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weaved between vehicles in an unsafe manner, and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGN, failed to keep balance on the walk and turn. The defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The IC was read, the defendant refused, a blood warrant was executed, and blood was collected.
Can you run his license, please? He gets a license.
Yeah, he doesn't know. So,
At 117 miles an hour, Mr. Shelby, I'm now taking away your privilege to drive. I'm appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral, but I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive.
Yes, sir.
At all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will revoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
Yes, sir. So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a STRAM device within 3 days. Within 3 days of your release, you will be required to get a STRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
It's a scramble.
It's a device that goes on your ankle so that we detect through perspiration whether you
Yeah.
consume it. All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with Fleischer and then.
Yeah.
All right. Thank you so much, Carl. I appreciate it. You sure you want to do this?
As we talked about probation, we talked about, the
You have
different
no
choices he
convictions.
has.
You have no as far as I see, no convictions. Now, after today, you're going to end up with a conviction on your record. From now on, you're looking at 90 days in jail for any new cases that you pick up, you know?
Yeah, the choice is, you know, you can get the defer, you can get the probation that we talked about, but you decided to do the time.
When you plead guilty to something, it goes on your record and it stays there for the rest of your life. You can never take it off. And it will affect you when you try to get a job, you try to buy a house, try to get a car, a loan for something, try to get an apartment. So that's what I'm saying. I mean, you're old enough to know that.
I was lost when you was like 90 days after.
No,
I was lost because.
No, what I'm saying, you pick up anything else in the future, from now on, it's a minimum of 90 days if you take this deal. Because they can enhance your punishment to a minimum of 90 days in the future.
You're not getting that as a time served deal. The judge
I'm
just
served
wants-
here, but what I'm saying is, you don't want to defer to try to keep it off? You just,
Sir. No, sir. If you look at the computer, I've been to TDCJ before. It don't matter. It don't matter.
That's,
I'm just gonna
that's
be
like
honest with you. It don't
I
matter.
don't see, I only get access to Harris County because I can't get them to give me access to anything else anyway.
I
So,
understand, but I can tell you, and
Okay.
at my time, I done did my lesson. So if time served, I don't have to go to jail. I don't have to look over my shoulder. That's fine with me. I walk a straight line. That just was a unfortunate happen with my problem.
you're charged with resisting arrest, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. Like I said, this is going to go on your record. It'll be there for the rest of your life. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, that's it.
I understand.
This is what you want to do.
Yes, sir.
How do you plead to the offense?
I plead guilty.
I'm going to find you guilty. I'll follow it. Good luck to you, Mr. Pack.
give me
Take
1
care.
second, get you this piece of paper, go downstairs so you have to make court cost.
All right.
I'll be with you.
I think the offense date was March the 30th, sir. So a little more.
No more.
Sure.
I'm going to test you 50 days from today.
Sure.
If I find that you continue to use, it's not going to go well for you. Do you understand?
Sure.
Do you have a job?
No, not at the moment.
It's time. It's time for you to start working and being productive. When you have too much time on your hands, you become self-destructive. That's what we don't want. I don't want you to pick up a 6th case or 7th case now within the next, that's it. I'm going to bring you back in 2.5 to 3 weeks and I want to see what you have done to get a job. If you've done nothing, you understand.
Yeah.
All right, good luck.
And he did let me know he has enrolled in HCC for the summer session of college.
That would be great. That's great. But if you're taking 6 hours, you got to do something else as well. If you're taking a full load, then great. The more schooling you do, the more money you're going to make in this life. Knowledge is power, and with knowledge, you get money. That's what this life is about, not convictions. Do you understand?
So,
Good luck. Thank you. Yes, ma'am. All right.
I apologize, Judge. I was in court 4 and just sitting there for a while until.
Don't worry about it. You're good. We're glad that you made it. Did Stradley come here today?
Yes, he reset it.
He already left?
Huh?
He already left?
Yeah, he already left.
Okay. Because we need to do conditions. It's a second. It's a DWI second. We need to do conditions. And I know, but I still want to put conditions. He's going to bond out, I would imagine, right? No, but I'm putting conditions first. I want to get conditions so we get a guardian interlock and now, yeah, see, yeah, I mean, I want to put conditions on, you know? And if you can't say that we can give him someone in the interest for now, just for purposes of conditions, okay? It's okay, Tom, hear you.
Tom, I'm gonna send you an email on this one. I think we've got it worked out.
All right.
Just let me know when you're ready, okay? Hi.
Thank you, Judge. I just wait here in the link.
Yes, ma'am. Good morning.
Good morning, Judge. I'm here on an off-docket matter. Is that okay?
Yes, okay, of course. What's your cause number?
There's two and, Judge, hang on.
I forgot my eyeballs too.
There's a DWI and that's cause number 2556097. And there's a tampering.
This is on Mr. Hernandez?
Yes, sir.
Are you representing him on both?
I am, and Judge, we just realized, I'm sorry, my staff, I just filed the notice of appearance on the tampering. We didn't realize he had two.
We have you connected.
Okay.
It looks like he has an ice hole.
Well, yes and no, that's why we're in front of you. So he apparently posted maybe the PR bond here. I got him from the jail. He went to immigration. April 2nd, posted a bond there. But we've got two warrants. I believe these warrants are holding him. And so didn't know if, I think Harris County maybe has 10 days. I don't know for sure. They have a certain number of
What
days.
happens is that we don't get notice, or I guess we didn't realize that he's in immigration. We assume that he's out, he's gone on the lam.
Right.
So
And they didn't
we
have
issued
a
a
warrant
warrant.
to tell you, Judge, so.
So he's made bond on the immigration case?
Yes.
Okay,
yes.
so I can reinstate these bonds now,
Okay.
but as soon as he gets out, he needs to come here immediately for bond
Of
conditions.
course, okay.
So we need to set a day.
What's the case number?
You ready?
Yeah.
It's 255-6097. There's two. I'll reinstate it now, but if he's not here by the next setting, let him know that I'm gonna end up revoking him because he needs to come here for bond conditions. I guess just pick if you want like maybe a week or so.
Okay.
Yeah.
Thank you.
Yes, ma'am.
Appreciate it.
Of course. Did you get the cause number?
Yes.
There's two.
Anthony Hernandez?
Yeah, please reinstate both.
Yes, sir.
Yeah. Tom,
I filed a dismissal in that case. I filed a dismissal.
Are you talking to me?
Yes, I filed a dismissal on when?
I appreciate it. Thank you, sir.
I'll sign it as soon as I get it too, okay?
Thank you, Judge.
All right.
Thank you,
Take care.
counsel. Take care.
Reset, but I think the case is older than 150 days old.
Yeah, where are we headed?
We're waiting on the RIP call and the 911 call. I believe the state has sent an escalated request.
Yeah, we've requested the 911 call twice, Your Honor. I'm not sure why it's not in yet. I would just request if we could just have one more sentence, we'll try and reach out and hound somebody to get the 911 in. It is,
Subpoena them to come to court. That's what I would do, you know? So give them 10 days, subpoena them to come to court. And then if they provide it to you, then great. If not, then, you know. But if they can't get you just the 911, then that's as simple as possible, okay?
yes, Your Honor.
So a 10-day discovery hearing. Yes, ma'am.
Thank you, Your Honor.
Sure.
Good morning.
Yeah. Hi, Mr. Vela. How are you? What's new?
I've got Serato on your docket, copy to, like you see.
Thanks. You too. What's new?
Is discovery complete?
She's got a bond violation. She failed to show up to a drug screen. She was at work. She did test yesterday. She tested negative.
Great.
Yes, sir.
Okay. Is she here now?
She is here.
Am I bringing her over?
Yes, ma'am. Yes, sir.
Come up, ma'am.
And I'm gonna reach out to this man in the message. Sure. Oh, so we can finish this up. I want to see if I will get some colors. Yeah, perfect. All right.
I'm glad that you tested negative. Good job. Don't miss again, please. Okay, if it happens again, I'm gonna issue a warrant, okay? All right, good luck. Thank you. Thank you. Take care. Always. You said Miller?
Miller, Jeremy Miller.
Jail or bond?
Good bond. Waived.
Say it again?
He's waived today, but on.
Okay. threat, 156 days. It's an
Right,
old
I know,
case.
Your Honor, we've been trying to get in touch with the complainant. But I'll read PC, Your Honor. On November 3rd, 2024, officers were dispatched to 15 over terrorist threat call. Upon arrival, officers met with the complainant, who advised she's employed at Bentop Hospital as a registered nurse. Complainant advised that she was attempting to administer an IV needle in the arm of the defendant when the defendant stated, quote, "Bitch, take the needle out or I will kill you." Complainant said she for her life.
I mean, why?
So I would argue it's a conditional statement, Judge. It's take the needle out or this will happen. I think based on that, it's not an imminent threat, but it's a conditional. If you do this, I will do this. So I don't think it meets the statute for probable cause.
I mean, Your Honor, I would argue that, threatening to kill her in a hospital.
I mean, can that possibly be the law? So anybody can ever, if there's a condition, then it's never a terroristic threat?
I would need to look at the case law.
That would be,
I know there's somewhat of agreements.
let me pull up the statute. Hold on, let's see.
But I know that the way it's charged, Your Honor, is imminent serious bodily or that.
Person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to cause a reaction of any type to his threat, place any person in fear of imminent serious bodily injury. I mean, it doesn't say if it's conditioned that, because the statement is he's saying, I'm gonna what?
I said, quote, "Bitch, take the needle out or I'll kill you."
I mean, show me some kind of case law that says that a condition kills it, and then I'm with you. But I mean, there's obviously it's a threat,
I can look at
and the needle's in his arm at the time, right?
Correct.
Yeah, I mean, if you show me that a conditional statement it's no good, then I'm with you.
And then I also wanted to ask you about Todd Wallace. That's
I remember Mr. Wallace. How's he doing?
So, Judge, I've not been able to have contact with him. I went by yesterday in person, trying to reach him, and just have not been
You
able to
said
reach
it
him.
today because you couldn't get in contact with him, right? Okay. So I guess we'll revoke it.
And I spoke with Chief. He's essentially leaving the offer on the table of just an apology letter and a dismissal if he does end up back in custody. So I'll
Because
make a note of that.
I'll leave the first setting to Your Honor if he does come back.
Did you put that in the notes?
I already put a note in there, Your
Put a
Honor.
specific note for
I'm
us.
going to revoke it now just because you have no contact. If he should show up, then we'll talk.
The exact note I have, Your Honor, is proposed defendant is going to bond forfeit when he comes back into custody. I will keep the apology letter offer open for 1
Yeah,
second.
we just don't know what circumstances are going.
Yeah, I understand.
So I'll do 1501. Or, sorry, 2501. Hey, so 2501 on Wallace. And I'm not going to do a BO.